Hi, I'm Tom Spiggle, founder of the Spiggle Law Firm, and we get a lot of questions about severance or separation agreements, the documents that you get when you've been fired or let go from a job. And I'm excited to offer this educational piece to you because it's very confusing. You've been let go from a job, you get this document that can be anywhere from 3 to 10 pages of all this legalese, and you're not sure what to do with it. So we're going to take everything that we've learned over the past many years and seeing hundreds of these documents and share them with you and walk through what these documents mean, what some of the common pieces of them are, and how you should think about them and how you might want to try to negotiate them, or when you might want to seek legal advice about the document itself. We had originally planned to offer this educational video about severance agreements and how to read severance agreements as a paid service because we're packing so much value that we've learned over years into this. But given what's has gone on with the coronavirus and the number of people that are going to be unfortunately receiving severance agreements and wanting to know what to do with them, perhaps with no opportunity or ability to pay for attorney's fees or even for an educational product, that's when we decided to set up this, to set this up with all these lights and all these cameras and offer it for free as a service to people who are really in need of this information. As a preliminary matter, I want to, I've got to have the legal fine print here, right? Because I am a lawyer. This is not intended as legal advice to you. In order for it to be legal advice, I would have to know your particular situation. So this is intended only as an educational, this is intended only as an educational product for you, for education for you. So if you want legal advice as to your particular situation, then you need to go see a lawyer. So the way I'm going to do this is I'm going to talk to you, give you an overview first of what separation or severance agreements are. Then we're going to dive into a sample separation agreement. And then I'll follow up with some other key factors that you might want to consider with your own severance or separation agreement. So let's start with what a severance or separation agreement is. Those terms are used interchangeably. It really doesn't matter what you call it. A severance agreement or a separation agreement is essentially a contract between you and your former employer in which you, in broad strokes, you agree to release any right that you have to sue your former employer, and the employer gives you something. It's often money, it can be a reference, it can be any number of things. They give you something in exchange for, in large part, agreeing not to sue the company. There are some other things in these agreements that we'll be going through, but that's essentially what this is. It's a contract between you and your employer. Now, one of the key questions you have when you get one of these documents is, how long do I have to consider this? We get a lot of calls at the firm where people are panicked and they want to have time to review this and they're concerned about how much time that they have. It depends. Good lawyerly answer. The document itself may say, and often it'll have a cover page or a letter that goes with it, might set forth a time frame. It might say, the company where we would like a response within 2 weeks, for instance. Now, if you are over 40 years old, you are 40 or older, you are covered by something called the Older Worker Benefits Protection Act, OWBPA. And essentially it has a number of provisions, but essentially it says that by law, you have to have 21 days to consider the agreement, and then you have to have, even after you sign it, you have 7 days to rescind it if the agreement is asking you to waive your rights to sue for age discrimination, and almost all of them do. So know that if you're over 40, that you have those rights. If your employer knows what it's doing, and they don't always, then they'll know that and they'll give you time to consider it. Even absent that, if you're under 40, most companies will give you time to consider the agreement, not necessarily out of the goodness of its heart, although that may be part of it, but rather because they don't want you later to have an argument that you were coerced into signing this. So most employers will give you some time to consider it. Now, you will occasionally be in a situation where your employer through HR or whoever's having the meeting with you will slide this across the table and they'll want you to sign it right away. That's rare. If that happens, my advice is always that that you should take your time to consider it. You should say to whomever's in the room, I want to take some time to consider this. I think you can understand that I'm under some stress right now. I'd like to take this home and think about it. And most times they will allow that. Now, technically, if you're under 40, they don't have to give you any particular amount of time. So it is legal for an employer to say, this agreement is good only until you walk out that door. That's very rare, but that is legal. But I always recommend that people think about it. And again, most employers will give you that time. Okay, now what I'm going to do is I want to turn to an actual sample severance agreement. And you'll note that on this one, looking at it here, this is a generic agreement that we drew up for the purposes of use in this educational product. This is not intended to refer to anybody in particular, as they say in movies. Any correlation between this and actual events is unintended. This doesn't refer to any particular person or company. This is just a sample agreement. So let's get started here. And you'll see it's titled here, Agreement and Mutual General Release. Again, the title doesn't much matter. You will see on this one, you don't see on this one, but you will see on some, kind of a long whereas provision, whereas the company doesn't admit to liability, whereas parties enter this agreement in order to resolve this matter. You should certainly read those and understand that they don't really have much of a legal effect. It's not really a key part of the agreement or one that you really need to worry about. Here you'll note that it's just one paragraph where it says, in consideration of severance and termination benefits described below, another good and valuable consideration. And consideration is the legal term. In order to have a binding contract, consideration basically means I give you something of value in exchange for something else. And here they are giving you money or something else of value in exchange for your agreeing not to sue the company, among other matters. The sufficiency of which is hereby acknowledged by the parties. The parties hereby agree as follows. Again, that's a bunch of legalese, but it's basically like, hey, we're agreeing, we're entering into a contract here. We got the paragraph 1, we've got the actual termination date, paragraph 2, and again, this is not a severance agreement. These can be anywhere in the document. This is just a sample agreement. So it's not that every sample agreement, severance agreement, is going to follow this outline here. But the second paragraph here is the company is agreeing to pay your salary, and 2A here, Mr. Smith will receive his normal and customary paycheck dated April 23rd, 2020. Basically, you're getting your same W-2 paycheck, through the, for work that you have already performed. In paragraph B here, you'll note that this is the company is agreeing to pay Mr. Smith for time that he's not going to be at work as if he were at work. So we're firing you today, but we're going to pay you the next 2 weeks as if you were at work. It's just a form of severance pay. There's no right or wrong way to do this. Here, the company just saying we're going to pay you through regular payroll. Another way that companies can do it is just by a lump sum. They can pay you right up front rather than paying you through payroll. Here, they're just agreeing to pay you for a certain number of days, even though you are not working. These provisions are not uncommon. Sometimes, particularly for higher level employees, we'll see companies do this where they want you on the payroll, they want to have access to you, so if they need help with, finding where documents are, doing training, anything that the company may need, they don't care that you're not coming into work, but you're still on payroll. They reserve the right to call you to get help with whatever the company may need finding or with whatever transition that the company may need. So sometimes you will see that, your last day of work is this day, but we're going to pay you through a date in the future. You'll see in paragraph C and D here under 2, where they talk about healthcare benefits. And this is something to pay attention to. Obviously, it's a big provision, a big need for a lot of people. They get their health insurance through work. Here, there's a notification that after a certain date, they are no longer going to pay for your health insurance, but you have a right under COBRA. You have a right under COBRA, we'll bold it here, to receive payment, receive your health insurance benefits for a certain number of months. That's required by law. Again, the company's not paying your portion of the premium anymore, so sometimes it can be very expensive, but you have a right by law to COBRA continuation coverage. Note that this is also an area that you can negotiate. It's not just a matter of trying to get more in terms of lump sum payment or how long the company's going to pay you, although that's obviously important, but you can also negotiate how long the benefits will continue. One question we get a lot is what's required? How much are they required to pay me? And the answer is generally, unless there's another contract that says otherwise, there's no requirement that they pay you anything. For some high-level executives in particular, you might see an employment contract where there's a contractual, you've entered it into a contract where if you're going to be let go for something other than cause, like stealing or something like that, that the company agrees to pay you, to pay you a severance. Very few people have that, but there's no requirement that they pay you anything. As a rule of thumb, and it's only a rule of thumb, it's usually a week of severance for every year that you are with the company. So if you're with the company for 2 years, the rule of thumb is that you will get 2 weeks of severance. But again, that's just a rule of thumb. It's not a requirement under law. So if we scroll down here to paragraph E, they talk about paid time off. This paid time off, again, is not usually governed by law. I mean, whether if you've got accrued paid time off, whether you get accrued paid time off is usually a matter of the company's practice. So if the company has a practice of paying people out, it's often in the employee handbook, the paid time off that they're accrued when someone leaves, then you should get that as well. If it's use it or lose it, and the company has nothing in its handbook, and its policy is that it does not pay paid time off, accrued paid time off when someone quits or is let go, then you are not entitled to that. You'll see in subparagraph F here, 2F, that the company agrees not to contest your application for unemployment. In most states, if you have been fired for something other than cause, then you have a right to unemployment insurance, which you apply through, in this case, where this is a Virginia employee, a Virginia company, so that you can apply for that through the Virginia Employment Commission. Companies can agree as part of a severance agreement not to contest your right to unemployment insurance. Otherwise, a company can show up at an unemployment hearing, and say that you should not get your unemployment insurance benefits because you were fired for some reason for cause. And companies sometimes will do that. And here, under the severance agreement, they are agreeing not to contest your application for insurance benefits. Company property, you'll almost always see, I'm in paragraph 3 now, you'll almost always see this in the severance agreement. Basically, you've got to give back the company's stuff. If you've got a lanyard, if you've got a computer. Cell phones are something that can be tricky. It depends on, if you have a company cell phone, you've obviously got to return that. Sometimes you'll have, a personal cell phone that is also used for work, and there can be, often by your employee, under your employee handbook or a separate agreement that you signed with the company, that you agree to give the company access to your cell phone in order to remove any company data off of that. So that's something that you would want to be aware of. Often the companies have a right to that. You don't want to play any games here. You don't want to destroy company property. You don't want to give them a reason to come after you for that. And this is, often a good place to remind folks that the companies, they're going to get your laptop. Most of them will do what's called a forensic analysis of it, where they will pay an expert to, go through your computer and see what you've downloaded, see, any documents you may have taken with you. So just know that you can't, it's very rare you're going to, not that you would want to, but that you can hide that. We've seen people download thousands of documents on a thumb drive and then take it with them for their own protection or otherwise. A company's usually going to be able to see that. So just be aware of that. That doesn't mean that you might have a right to that. If it's your personal information, you may. But if you're going to download a bunch of documents, the company often will find that out, and it can really complicate efforts to get a severance if that's what you're trying to do. In paragraph 4 here, called no admission, this is often very common, where they're asking you to agree that no laws were violated here. So basically under paragraph 4, you are saying if you sign this agreement that you are not signing it and saying that this is, the company is admitting, they're signing it because they admitted they did something wrong. They're saying that's not the case here. We are just not admitting liability, we're doing this to resolve the situation. Paragraph 5, the general and specific releases, is sort of a key paragraph, and again, it may not be 5 in yours, in any severance agreement. And it essentially is where you are agreeing to release all the claims that you have under almost any statute to sue the company for almost any reason. And you can read through it. You see all the statutes that are mentioned here, and usually depending on what state you're in, I mean, they'll mention federal statutes and state statutes. The key thing is to remember that by signing this agreement that you are releasing all these rights. And once you sign it, again, unless you are signing it under the older worker, you're covered by the Older Workers Benefits Protection Act, and you sign it and you what's called rescind, or you take back your agreement to the contract in 7 days. Unless that's the situation, once you sign this, you are giving up your right to sue for almost any reason. And this may not be a big deal for you. If the company is letting you go as part of a reduction in force, you don't have any reason to believe that they discriminated against you or done something illegal. This may not be of concern to you. However, this is one area where you can't really tell whether the document is fair just by looking at what's in writing here, because you need to know if you are being compensated fairly, if you're being given enough money for giving up your rights, and you need to know what your rights are. So, for instance, if you have an email, let's say you complain about sexual harassment, you're fired. That's a pretty good case of retaliation. And in the severance agreement, they offer you 2 weeks of severance. So 2 weeks, 2 weeks of your salary for giving up this claim to sue. Well, that's not a very good deal. That doesn't really compensate you for giving up this right. And that's an area where if you have questions about it, it may be worth hiring a lawyer, or at least getting a consult with a lawyer to see whether or not you have a strong claim against the company. A couple of things to be aware of where you may have claims that you're possibly not aware of are like overtime claims, Equal Pay Act claims. At the time of signing this, you may not be aware that a person of the opposite sex who does the exact same job that you do is being paid 25% more. Or you may not be aware that the company has not really adequately paid you for all the overtime. And by signing this, you may be giving up those rights without even knowing that. And that doesn't matter. If you sign this, then you're giving up those rights to bring those cases. So it's just something to be aware of. Again, if the money looks okay to you, if you don't otherwise have a problem with the company, you're ready to move on, just understanding that you're giving up all your rights to sue under any law, which may not be important to you, just knowing that that is what you're signing here. Now, understand that there are some, it's rare, but I have seen severance agreements where they do not have this, where the company is offering you a certain amount of money, when they have other provisions in it, where you're agreeing to turn company property, those sorts of things. But they don't have a language in here that you're giving up your right to sue. Well, then it's perfectly legal for you to take that money, to sign it, take that money, and then turn around and sue the company if you believe you have a claim against it. So this is really one of the key provisions. A couple of things to know: you can't be forced to give up certain whistleblower protection right acts. So if you're aware that the company is doing something wrong or overbilling the government, you can't be forced generally to give up those claims. You can't be required to give up your right to file at the EEOC, or the Equal Employment Opportunity Commission, which is the federal, the federal administrative agency that oversees laws applying particularly to discrimination, also to Americans with Disabilities Act claim. They can't force you to give up the right to file what's called a charge with that organization. They can force you to give up your right to receive any compensation. So you can still bring a whistleblower, you can still file a charge at the EEOC, but you can't get any money from it. So understand that they can't prevent, you can waive a bunch of rights. You can't waive those, but they can force you to, or they can get you to agree that you won't receive any money if you later do file under one of those laws. You'll see in the bottom of page 4 here, you'll see that this is in bold, that basically you are agreeing to release these claims knowingly, even if you're not aware of all the facts that may give rise to them. So again, like, you may not be aware that you have an overtime claim, but once you sign this, you give it up, even if you've given up that right to sue, even if you later learn that they didn't properly pay you for overtime. So again, may not be a big concern for you if the money's right, if you're ready to move on. It doesn't affect you proactively. I mean, by that I mean, when you go on to work at another company, you're not giving away your rights forever, but you are giving it away with this employer. Mutual release. Basically, you are agreeing to, it's saying, you are agreeing to give up all your rights to sue, as we talked about before, not only against the company, but any of its subsidiaries or other companies that may own. You are giving up the right to pass your right to sue on to, you give this to one of your heirs if you still have a claim when you die, if you've signed this agreement. Again, it doesn't come up for most people, but that's what some of that legalese means. When it says mutual release here, it means that the company is also agreeing to pursue any claims against you. Often that's not a big deal. You would know, right, often as a part of this negotiation, if the company thinks it has a claim against you. That's pretty rare that the company has a lawsuit that it can bring against you, but it's not out of the realm of possibility. And so in a lot of these, you'll see what's called a mutual release. Hey, you agree not to sue us and we're agreeing not to sue you. Just understand that in most instances, it's not a great value to you by saying, hey, I'm giving up, the company, I'm agreeing that you don't have any rights to sue me. That being said, all things being equal, it's better to have a mutual release than to not have one. If you're negotiating one of these, is it something that I'd fight for? Not necessarily. I mean, unless you really think that the company has some sort of claim against you that they might be able to pursue. Let's see. Number 7. You'll usually see something like this, that if you have any ongoing claims against the company, that you'll agree to dismiss those. It's pretty rare that we see people come in and they've got an ongoing claim against the company. I mean, if you're part of a class action, I mean, certainly if you are involved in a current lawsuit against the company, then you want to have your attorney review this, because by signing this, you may well be agreeing to dismiss that. Non-disclosure, this is a big one. You've seen this a lot in the news, in the Me Too movement in particular, that you are agreeing not to discuss this with anybody. Often it'll say, even with, let's see, if you look at this, the non-disclosure, number 10, the confidentiality, that you're agreeing not to disclose or talk about this settlement with anybody. You see number 10, keep the agreement and its terms confidential and will not discuss them publicly or disclose them in any manner inconsistent with the full confidentiality except to an attorney or an accountant. Sometimes you'll see in these agreements where it says even the attorney or accountant has to agree to be bound by these provisions. They don't make them sign it. Just know that you're giving up your right to talk about what happened to you at work in large part. Now, of course, that doesn't apply if you're subpoenaed by law enforcement or as part of another lawsuit. Say another employee brings a lawsuit and you're subpoenaed to give a deposition. These would not cover those. But you can't go to a party and talk about it. You can't start a blog and talk about it. You can't comment on social media and talk about it. You know, and companies, the truth is companies are not going to follow you around generally with a you know, with a private detective and see if you're talking about this. If you, I mean, I'm not recommending this, but if you mentioned it to you know, somebody about it offhanded at a party, I mean, unless it gets back to the company, chances are it's not going to cause you a problem. But if you're, you know, if you're commenting on social media, I've had, not our clients, but I've had people comment on some things that I've published on LinkedIn about employment law rights, and somebody has posted about an experience that they had, and I've had a company, not against me, but come after that person and say you have to take this down. So just understand that companies will enforce this. This severance agreement doesn't have this language, but what you want to be careful of here are what are called a liquidated damages provision, and that's where it says, you'll usually have some language where parties agree that if you violate this, that the company doesn't have to prove that it's been damaged. Normally under a contract, a violation of a contract like this, the company would have to prove that they were damaged. So if you went and you violated this contract by going and talking to somebody at a party, the company, in order to, I mean, they could sue you and they could show, yeah, they violated the agreement, but the court's gonna be like, okay, what are the damages? Were you hurt in any way, company? And that can often be very difficult to show because often there isn't any real damage. And you'll see what's called a liquidated damages provision where the company will put in here, you know, parties agree for any violation of the agreement will involve a payment of $5,000 or return of the severance. That's something to really be aware of because obviously it can be very expensive to you, and you want to make sure that not only you aren't talking about it, but your family members aren't talking about it, you're not violating these provisions. One pro tip here is you want to try to make this as much as possible mutual. By that I mean, you know, the company agrees not to say, you know, something bad about you. You know, they often will agree not to say, you know, maybe give a positive reference, or at the very least give what's called a neutral reference. A neutral reference is where, you know, if somebody calls for a reference for you, somebody you're interviewing with, that you'll agree to just give them the date. They will give just the date you worked there, your title, and perhaps your salary. That's very common. It doesn't usually raise red flags, but again, that can be a mutual provision where you can ask for it. You can say, hey, look, the money looks good. You know, I'm just asking that this non-disclosure, this confidentiality, or this, you know, looking into number 11 here, this non-disparagement, that it be mutual, that you agree to give me a positive reference. You know, sometimes the company will even agree on the language, or at least a neutral reference. And then we're getting here to number 11, the no disparagement. You know, you're agreeing not to go out and badmouth the company. This is a part where you can also ask that the company agree not to disparage you, not to say bad things about you. Understand that sometimes companies they'll say, well, I'm not gonna, if you're dealing with other lawyers, say, I'm not going to agree to not say, the company, let's say the company has 5,000 employees, they'll say, well, I'm not going to agree to what's called a blanket non-disparagement on behalf of the company, but I will agree that your supervisor and that the key employees around you agree not to disparage you. And that's usually pretty acceptable, because the chances that, you know, Marge in North Dakota, who you don't even know, is going to disparage you or say bad things about you is pretty remote. So we've talked about the fact that under these three provisions, the confidentiality, no disparagement, and the non-disclosure, that you are basically barred from talking about the events that led up to signing this agreement. That doesn't mean you can't talk about your job, but you can't talk about, you know, how much money you got. You can't talk about, you know, what's leading up to this. In many situations, particularly if you know, you're not being fired, you're being, you know, let go as a part of reduction in force. The company may not care that much, you may not care that much. When it tends to be more of an issue is when something significant happened to you. For instance, we've seen in the Me Too movement, if you were subject to sexual harassment, so it's really emotionally damaging to you, and now you're signing this and you can't talk about it. It's just something to be aware of when you're thinking about, you know, what the money is involved here. What is how much is the company paying you for giving up your right to speak about it? So just be aware of that. Read these carefully. If it's a concern to you, these are another area where it may be worth it, even if you don't hire a lawyer to represent you, to hire a lawyer to at least look at these provisions and see if it's something you need to be concerned about. Non-solicitation provision here, number 12. Sometimes you'll see these in severance agreements. It's not uncommon, not in all of them, but essentially this says that you agree not to, not to try to steal company employees is what a lot of it means, or trying to influence them, influence them to leave with you. This is rarely a situation. Where it tends to come up is if you are, let's say you are going to work for another company. It doesn't otherwise violate a non-compete, and we'll get to that in a minute. And somebody calls you and says, "Hey, I'm thinking about leaving too. Can I come? Should I come join you at your company?" You might run afoul of the non-solicitation agreement if that happens. Also, the company's clients. It usually means that they're non-solicitation. You can't go after company clients and try to get them to come with you. Again, something to be aware of if your Rolodex is really important to you. I see this a lot in sales. You're getting ready to open up a new business, and you might be working with the company, company clients. The non-solicitation, may apply to you. So it's something to just be aware of. For most people, it doesn't matter. If you're not in sales, if you're not planning to take people with you, it's not really something that's going to affect you. But if you're a high-level salesperson, this is something you might want to take extra attention to look at. You might want to have a lawyer at least look over it because it could really impact your business. And again, these are things that can be negotiated. The time period in this one in paragraph 12, it has a period of 12 months. You can agree to a lesser period. Also, this is true for non-solicitation, and while we're talking about it, non-competes. This one does not have a non-compete as part of the agreement. Some of them will. They'll have a non-solicitation, they'll have a non-compete agreement, and the non-compete agreement will say one of two things. It'll say that you agree to continue to be bound by a non-compete that you've already signed. Sometimes the non-compete agreement will be brand new. It'll be a provision of the severance agreement. And again, this is one that you just want to, if it's important to you, you're a high-level salesperson, you're planning to leave to work at a company that is competing with this one, your former employer, well, you may not want to sign it. I mean, the money may not be worth enough to you. Now we're to paragraph 13, the complete agreement. And this is an important provision that's almost in all severance agreements. And that is, essentially what this means is that everything that you're agreed to is in this document. Lawyers call that within the four corners of the document. The reason that could be important is, if you're having a conversation, let's say with your HR department, with your former boss on the way out the door, and they agree to do something. Let's say they agree to give you a positive reference, they maybe agree to a severance or whatever may be important to you. If it's not in this document, it's not part of the severance agreement, and the company's not bound by that. So it's just something to be aware of, because it's not uncommon for there to be representations made, when you're at the meeting by HR, by somebody else at the company, and maybe they're not trying to sandbag you, they're being sincere, and it doesn't get put in this document. And then it's not enforceable. So if somebody, made an agreement to do something that's important to you and they did it orally, they didn't do it in writing, maybe they agreed again to give you a positive reference, you want to make sure that it's part of this agreement. Otherwise, if it's not, then they're not bound by that. You can't make them do that. Number 14, attorney's fees. This is a key one too. So this one we'll just read since it's short. The prevailing party in an action to interpret or enforce this agreement shall be entitled to reasonable attorney's fees and costs incurred. What this means is that there's a fight over this document. Let's go back to the non-disclosure provision, and the company says, you know what, we think you were at a party and you told everybody at the party, about the money that we paid you in the severance agreement, and that's a violation, and we're going to sue you because of that. If they sue you and they win, that means not only do you have to pay your own attorney to defend you, you have to pay their attorney to bring this action, which could be really expensive. And we saw this some in the Me Too movement, where this is a significant hammer, where you sign a non-disclosure agreement, you decide for whatever reason later that you want to talk about it, and you are risking being sued and losing and having a $100,000 bill that you have to pay. When negotiating these, I like to see that with both sides will what's called bearing their own attorney's fees. Essentially, if you sue me, I sue you, I pay for my lawyer, you pay for your lawyer. The winner doesn't have to pay the other side's legal fees, because the truth is, in most instances, the company's got a lot better, deeper pockets than you do to try to pursue these things. So that's one thing you want to be careful of. Again, if you're looking at this and you're like, you know what, like, I don't have any reason to talk about this, the money looks fine to me, I don't plan on violating this, are the chances, are they going to come after you? Are you really going to get sued? Probably not. So, if it's a take it or leave it situation, would I, say leave the money on the table because of this? No. But something to be aware of, and again, if it's highly contentious, if you think there's a possibility that there may be a fight later over non-disclosure, then this is something that you're going to want to negotiate. Because remember, until you sign this, you're not bound by any of this. This is just, these provisions only come into effect if you sign it and take whatever money they're offering you. Number 15, governing law. Now, this is sort of a tricky one. It's maybe surprising for you to learn, but you can agree by contract to where, if there's going to be a battle here, where it's going to be fought and which law applies. Here you'll see sort of a funny one, hypothetical, but it does happen, where they're saying, if there's going to be, if there's a dispute about this, and there's going to be something filed in court, it's going to have to be filed in a court in Virginia, and that the state law of Delaware will apply. And courts do this all the time. You bring a lawsuit in Virginia, or you are sued in Virginia, and the Virginia court applies Delaware law. Sort of strange to think about, but that is happens. It happens all the time. Does this matter to you? Again, only to the extent that you think there might be a fight over it. It can matter, and oftentimes you don't know at the time when you sign this. But it could matter if you sign this and you say, yeah, I agree that if there's a fight over this, it's going to be in Virginia. Yeah, I agree that it's going to be in Delaware. And then you move to Colorado. And then let's say there's an argument. We go back to the non-disclosure agreement, and the company says, you know what, we think you violated the non-disclosure agreement. Or let's say the company doesn't pay the money that they agreed to under this, and you decide you want to bring a lawsuit. Well, then you've agreed that any lawsuit that you're going to bring is going to be in Virginia. That means you have to hire, you're in Colorado now, you have to hire a Virginia lawyer, and it means that the law of Delaware is going to apply. Is that good or bad for you? Who knows? It depends on what the claim is. Some state laws tend to be better for certain claims than others. Maybe a breach of contract claim would be better to bring in Virginia than it would be in Delaware, but you've agreed to bring it under Delaware law. Is this something worth fighting for? Again, if the agreement otherwise looks good, you don't expect that there's going to be any reason to fight over it, this is not something I would negotiate. It's something you could try if it's a small employer, and a lot of times something to consider is that the employer may have gotten this agreement off the internet. They may not even really care so much about these kind of provisions. You might say, hey, can we all agree we're going to bring it in there, or we're just going to take that part out. You might try to negotiate that, but often it's just not worth it. Number 16, severability. So this is another legal concept. Basically, it means that if this later is challenged in court and the court looks at this and says, you know what, and I'm just pulling this out of hat, I find that paragraph 15 is not enforceable. It's not a provision that is workable under the law. What severability means is that the rest of the agreement is still good. It's not a situation of where, hey, one paragraph's out, the whole thing is out. I rarely see this come into play. It's not worth something, it's not worth something to fight over this with. I've never seen it be an issue, but just know that that's what it means. That if there's an argument later about the applicability of one of these paragraphs, if a court looks at it and says, well, I find that the non-compete provision does not apply, it just means the rest of it is still enforceable. It's number 17. You acknowledge that you received it. Number 19, counterparts. The agreement may be signed in counterpart. That only means that you don't have one document with both signatures on it. Like, okay, the employer signs on one document, I sign on the other, then it's an enforceable agreement. We don't have to have the signatures on the same document. It's just a matter of convenience. Again, not something I see that's worth fighting over. So that's really what 99% of severance agreements are going to look some version of what we've seen here. And again, the really key parts for you to be aware of are the non-compete, non-solicitation, to know whether that is important to you. Also understand that particularly for non-compete and non-solicitation, if you're going to do something like you're going to go out and start another business, if you're going to go work for an employer that is in the same field but doesn't compete with your current employer, and you may want to talk to a lawyer about this, but one possibility is that you raise this with the company before you leave. I often see where non-compete and non-solicitation provisions really get nasty is when the company is surprised by it, right? You go out and you start a business, you're not planning to compete with your company, but your company was unaware that you're going to do this, and now they decide they want to come after you. So sometimes it's in your best interest to be upfront with what your plans are with the company and for everybody to agree that, hey, this non-solicitation provision does not apply to this. Sometimes you can even get that written into the agreement. The non-solicitation provision does not apply you going to work with, company B over in another state. Just something to consider. Again, if it's important to you, you really want to have a lawyer look at that. If you're in high-level sales, if there's going to be an issue, for instance, like are your LinkedIn contacts, if you make an announcement on LinkedIn and you're a high-level salesperson and a bunch of your contacts were also customers of your now former employer, does that count as non-solicitation? Again, you're not trying to steal customers, it's just you made an announcement. Sometimes you can, if you're concerned about that, you can agree with your employer when you're leaving that that's not going to be a violation of non-solicitation. The big piece, again, which claims you are releasing, and you can assume that unless they didn't know, the company didn't know what they were doing when they drafted this, that if you sign it, you're agreeing to release any claims that you may have. If you think you have what's called a valuable claim, you're going to want to talk to a lawyer about that and make sure the company is adequately compensating you, giving you enough money for agreeing not to sue. Because remember, until you sign this, you're not you're not bound by any of this. So if the money's low and you're troubled by some of this, maybe you just turn it down. Why take 2 weeks of severance, let's say, and be bound by some really perhaps draconian provisions, let's say a non-solicitation or a non-compete that really could prevent you from working at a company that you want to work for. It may not be worth it to sign this. So remember, none of this applies. Most of this does not apply unless you sign it. So really understand that you've got some leverage there. So those are some of the key parts of a severance agreement. Let me talk to you about some things that will not be in the severance agreement that you may want to be aware of. A couple of them I've already referred earlier to the Older Workers Benefits Protection Act. If you're over 40, the company is obligated to give you 21 days to consider the agreement, and then 7 days to change your mind after you've signed it. I want to show you something. If there's been a big reduction in force, the company will be required to give you a notification of the ages of the people that it let go. I'm showing you now what would be one of these notifications. If that's the case, if the company is engaged in a large-scale reduction in force, then as you'll note here in this letter, you'll be given up to 45 days, and that's by law under the Older Worker Benefits Protection Act. You'll be given 45 days to consider the agreement and 7 days to change your mind after you've signed it. And you'll see here that it will list the ages of the people that were let go and the categories that they were in. So if you see that, that's why. It's because the company is letting go of a number of people that are covered under the Older Worker Benefits Protection Act. Another one is called a WARN Act notice. And this is essentially when a company is doing, the WARN Act is a federal law that applies to companies that are doing large-scale reductions in force. They're closing a plant. It generally applies to employers that have more than 100 employees. Then they are required to give you a WARN Act notice usually give you 60 days notice that you're getting ready to lose your job. If for some reason the company can't give 60 days notice, there's some intervening circumstances they can give less, but that's why you might want to see, and you've got a letter up here as an example of a WARN Act notification. You can sue a company for violation for failing to comply with WARN Act. There are a number of attorneys who do this sort of work. So know if you get that letter, that is why. If you didn't get the 60 days notice, that may be a violation and something for you to consider. Another thing that you should be aware of is if you are a uniformed service member, you're a member of the military, you may be aware of the Uniformed Services Employment and Reemployment Rights Act of 1994, only a lawyer could name it that, USERRA for short. And under USERRA, you should be aware that there is a specific part of that law that says that if you are giving up a right to bring a claim under USERRA, and where sometimes you'll see it happen is, employer will refuse to reemploy somebody who's coming back after deployment, or there's an allegation of discrimination based on military service. If you are giving up your right under USERRA, the company you have to specifically waive that, and the company has to give you something of value above and beyond what you would normally be entitled to. That can be a little mushy, as we talked about earlier. Often you're not specifically entitled to anything, but it can be a tool that you can use to negotiate for better severance. And if sometimes courts have found that severance agreements have been unenforceable if they did not specifically include language that notified you that you were waiving your rights under USERRA. Now, let's talk about, finally, whether you should negotiate one of these severance agreements. One thing to be aware of is that this is, as we talked about earlier, this is a contract negotiation, which means that when an employer makes a severance offer, they give this to you in writing, that offer remains open until they specifically take it back or until you reject it. And by giving a counter offer by saying, you know what, I'm not going to sign this unless it includes this provision or this much more money, that's a counter offer. You have technically, as a matter of law, rejected the first offer. Under law, the company is under no obligation to put that former offer back on the table. So it is possible, it's rare, but it is possible that a company offers you a severance agreement, you come back with a counter offer in any aspect, and the company says, you know what, not only do I not agree with your counter offer, but I'm taking my other offer completely off the table. Again, that's pretty rare. Companies usually want the release of claims, they want the non-disparagement provisions. These are valuable, the company's getting something of value. So usually at the very worst, the company will say, we'll decline to negotiate and we'll leave that offer on the table. But it's just something to be aware of, particularly if you know you come from an employer that is very litigious and might be willing to play that kind of game. In the vast majority of cases, the worst that you're going to get is they'll decline your counter offer and will leave that current offer on the table. But it is something to be aware of. It's also true if the company agrees to leave the offer open for a certain amount of time. Let's say you're not covered by the Older Worker Benefits Protection Act. The company says in the cover letter, we're going to leave this offer open for 14 days. And you let the 14 days come and go, well, then that offer is technically off the table. Now, usually in most cases, the company will put that back on the table and will say, well, at least give you what they previously offered, but it's not a guarantee. So it's just something to be aware of when you're considering whether or not you want to negotiate this sort of agreement. If you do want to negotiate these agreements, then you can either do it on your own. We offer a program called the Legal Leverage Program designed just for that. You can have an attorney advise you behind the scenes on how to negotiate it. You can do it without an attorney, and you just you write back or you talk to HR and you say, I'm willing to sign an agreement, but I need another 2 weeks of severance, or I need an extra 3 months of my health care coverage. These agreements are not set in stone. You can modify them or request whatever modifications that you want. Company is not obligated to entertain those, but they often will. Another thing to consider when you're doing this is, again, even if you are not, let's go back to the claims that you are releasing against the company. Let's say that you don't have any indication or any belief that the company has violated the law. And so they owe you more than what they're offering. You still can negotiate these. Keep in mind that, again, the company, these are valuable to the company. They're not just giving you something, they're getting something. They're getting that release of claims because, again, if it's a large company, they don't know what all their employees are doing. They don't know if somebody has, in relation to you, violated the law. They don't know if the accounting department made a mistake and didn't pay you proper overtime. So one piece to think about when considering whether or not to negotiate this on your own, the company is getting something of value from this, even if they arguably didn't do anything wrong. They're getting the release of claims, which is really valuable. Even if the company is pretty sure that it didn't do something wrong, it often doesn't know, particularly if it's a big one. They don't know what all the managers were doing. They don't know if accounting made a mistake and didn't pay you overtime. They would prefer not to have those claims hanging out there for years. They'd like them wrapped up. So when you sign that release, you're wrapping up all those potential claims they don't know about. You're giving them peace of mind. They're also getting that non-disparagement, non-disclosure right? You are signing a contract agreeing not to speak badly about the company. Yes, it is true, even without signing something, the company could sue you for defamation for saying things that are untrue, but until you sign this, you can say anything that you believe to be true. You can go out and talk about what a terrible place you thought it was to work, how badly you believe you were mistreated, and there's very little that the company can do about that. If you sign one of these agreements, you give up that right, which is a big deal for the company. So just understand that when the company is sliding this across the table, they are getting something of value. They are getting that release of claims. They're getting the non-disparagement and non-disclosure. These are things that you are giving the company when you sign these, and that's why they put the money on it. So those are things that are always up to negotiation. So even if you don't have a smoking gun email that proves the company violated the law, that doesn't mean you can't try to negotiate it. It does mean you probably will take a different tone. You don't want to come back and say, well, I believe you violated the law, therefore you owe me more money, because you don't have a belief of that. But you could say, either through your attorney or on your own, something to the effect of, I provided this company, I'm just pulling this out of a hat, 10 years of good service. You were offering me 2 weeks of severance. I don't think that adequately reflects the service that I provided to the company and the release of claims and other things that I'm signing. I'd be willing to sign it for whatever, insert your value there. 10 weeks of severance, I'd be happy to sign this. Again, you don't have to have an argument that the company violated the law to negotiate it. As always, to get specific legal advice about your situation and the rights that you are giving up, you should probably go talk to a lawyer, even if you don't hire one to negotiate this. And know that in many cases that you've got some time to think about this. You don't have to sign it right on the spot. You don't have to sign it within 24 hours. If the company's pressuring you, you can ask for more time. As a legal matter, and this is important, for most discrimination claims, you have anywhere from, if you're a federal government worker, you have 45 days, but if you're not a federal government worker, you may have as many as 180 days or more before you lose your legal rights to bring a claim. So it's not as if you have to rush and sign this. Take your time to think about it. If you need to see a lawyer, please take time to do that. But in the meantime, I hope this was helpful. It gives you some peace of mind if you are facing one of these agreements.